Welcome to the Gambone Law Podcast, brought to you by Gambone Law, a Philadelphia-based criminal defense law firm. My name is Alfonso Gambone, and I am a criminal defense lawyer who practices in courtrooms throughout southeastern Pennsylvania and all of New Jersey. This weekly criminal defense law podcast addresses and discusses some of the most common questions and issues within the area of criminal defense, with a focus on Pennsylvania and New Jersey law. It is based on questions from our clients and their families that we have taken over the years. It is my hope that this law podcast will help you and your family make better decisions during a difficult situation. Our law firm is committed to providing the highest level of professional representation to its clients, and educating them and their families about their legal rights under the Constitution. For previous episodes of this podcast, to read my weekly blog, or download one of my free criminal defense strategy books, visit gambonelaw.com or call 215-755-9000, 24 hours a day, 7 days a week. Finally, this podcast is made for information purposes only and does not in any way establish an attorney-client relationship. Please enjoy listening. Hello again, my name is Alfonso Gambone, and welcome to the Gambone Law Podcast. This is episode 2. This podcast is where we discuss common questions that we receive from clients and their families. Every week I discuss a different issue. This week I will be discussing drunk driving, which is a very common offense that our law firm defends in Pennsylvania and New Jersey. So the first question I have is, how many types of DUI charges are there in Pennsylvania? Well, there's actually quite a few. There's actually in total about 9. The most common offenses that we see in Pennsylvania are Section 3802A1, B, C, and D, and I'll speak about those briefly. 3802A1, it's a general impairment DUI offense, which is a drunk driving offense where the Commonwealth must establish impairment and that you are not able to safely operate a motor vehicle in Pennsylvania. And they can do that simply through the officer's testimony. They do not need any type of blood alcohol content or concentration through a breathalyzer or blood test. So it's a general impairment DUI. The other statutes all require the Commonwealth to present some type of BAC or blood alcohol content or concentration. And with those drunk driving statutes come with penalties, obviously. With regards to DUI offenses, again, 3802A1 is general impairment. 3802A2 is not general impairment, but requires the Commonwealth to produce evidence of a specific BAC level. Now, with regards to DUI, a lot of these sections of the DUI statute will require the person to incur a license suspension. 3802A1, however, there is no license suspension, but obviously it's still a conviction. Next question. Do all drunk driving convictions automatically result in a driver's license suspension in Pennsylvania? Well, I just answered that one. I may be eligible for the ARD program and that it will substantially reduce my possible license suspension. This sounds great, but I've been told that I may be ineligible. What makes a person eligible or ineligible for ARD? ARD normally is considered a first offender's program. So if you have any type of prior criminal history, you will more than likely not be eligible for the ARD program, which stands for Accelerated Rehabilitative Disposition. There are some situations where even if you have a lot of arrests, the Commonwealth may not give you ARD or obviously agree to it. With regards to the ARD program, it's important to understand that in many cases it is a good result, but when you meet with your criminal defense lawyer, that person should still explain to you the strengths and weaknesses of your case. ARD is a good option because obviously you will not incur a criminal conviction and in most cases reduce the license suspension. But your attorney should still go through the process of evaluating the elements of the offense with you, and as well as any kind of pretrial motions, which all could be possible defenses. I have had cases where we have actually rejected ARD and gone to trial and been successful. So The fact that you're eligible for ARD doesn't necessarily mean that you should take it. There are costs associated with it, and in some cases, those costs are very substantial. In addition, many of the ARD programs do carry with them some type of license suspension. Now, it won't be for a year. It could be 30 to 60 or 90 days. But again, you have to be aware of that. It isn't just simply a freebie. Also, if you accept the ARD program, it will count against you if you incur another DUI offense in the future. So if you have a DUI which results in an ARD disposition in, say, 2015, and you incur another one this year in 2020, the one in 2020 will result in a second offense penalty. And depending on how high your BAC was, that will dictate what tier you fall under. So the fact that you had ARD in the past will count as a first offense. Remember, DUI, unlike many offenses in Pennsylvania, is considered a tiered offense. So there's obviously the offense itself, and then within that offense, there's the tier. First offense obviously is the least serious, and the third tier is the most serious. And the penalties follow those tiers. If you are charged with drunk driving, the Commonwealth, the burden is on them, and they must establish all the evidence beyond a reasonable doubt. Okay, next question. What is a motion to suppress evidence, and how can it help me in my drunk driving case? Well, a motion to suppress is a pretrial motion. You have to understand that when you are charged with a drunk driving offense and you've made the decision to go to trial, you have options at the pretrial level and at the trial level. Trial level is focused on your defense and establishing reasonable doubt with regards to the elements. And your pretrial phase of that is looking at issues with regards to, in most cases, your rights against illegal search and seizure. Now, when it comes to a drunk driving offense, many people don't understand how a search and seizure issue could be an issue in a drunk driving case. We're not talking about drugs or a search of a house, but you have to understand that search and seizure covers everything from the stop of your vehicle to probable cause to arrest you. So if you're stopped for drunk driving in Pennsylvania, there has to be a legal basis for that stop. In most DUI cases, your criminal lawyer should explain to you that police need probable cause to stop your car and they need probable cause to arrest. Now, there are some limited situations where it's been argued that police can stop a car for less than probable cause for what is known as reasonable suspicion, which is a lower form of probable cause. But for the most part, the legal standard that a court will look at is probable cause to stop and probable cause to arrest. And a motion to suppress evidence attacks those issues. Now, during a motion to suppress, the evidentiary burden of proof is less. It's still in the Commonwealth, but it's a preponderance standard. It's not beyond a reasonable doubt. So it's a lower evidentiary standard, but it's a very powerful motion that your attorney should review. And in many cases, it is the strongest argument you have because the arguments at trial frequently, once you get past probable cause to stop and arrest in your pretrial motion, the only remaining issues are impairment and control of the vehicle. Next question. What are the elements of a drunk driving offense that your attorney can argue with regards to your defense at trial? I don't understand quite the question in total, but I'm going to do my best. With regards to the elements of the offense, it's very important that the Commonwealth establish beyond a reasonable doubt all the elements. And the most important element, first of all, is control of the vehicle. Now, most people believe that police have to find you actually driving, and that's simply not the case. They can establish control with you being behind the wheel and the keys being in the ignition. There's actually a case law which says that a person who's even parked on the side of a road is in control of the vehicle and thus can be convicted of drunk driving. With regards to impairment, that can be established in a number of ways. They can establish it through the officer's testimony with regards to your presentation. How did you look? Were your eyes bloodshot, glassy? How was your movement? Was it awkward? How did you do in the field sobriety test? How did you respond to the officer's questions? All that is relevant with regards to impairment. And the officer's testimony with regards to whether or not, in his or her opinion, you could safely operate a motor vehicle on the streets and roads in Pennsylvania. The other way with regards to impairment that the Commonwealth can establish its burden of proof is through chemical testing. Now, looking at this, that can be done either through a blood or breathalyzer test. Blood is more accurate, but obviously a breath test is much more convenient. There's been a lot of litigation in Pennsylvania with regards to blood evidence, and it's important that your attorney discuss both of these tests with you. Next question. What are the biggest problems that you see that people make with regards to drunk driving offenses in Pennsylvania? Well, there are three. The biggest thing that I see in our office is responding to the officer's questions after you are stopped for drunk driving. You have to understand that you don't have an obligation to answer any questions. If you are stopped by a police officer, you are obligated to give your license, your registration, your insurance information, and that's it. You don't have to answer any questions with regards to where you're coming from, where you're going, where you've been. None of that is required. And I can't tell you how many people, when they're stopped for drunk driving and the officer asks, where are you coming from? They'll say something like a bar or a restaurant, or I just had a few. All that is admissible and none of it is required. So that's the biggest problem I see when a person is stopped for possible drunk driving in Pennsylvania. Now, I'm not telling you to be rude to the officer or impolite. I'm telling you that just give what you were required to give, and that is it. The next issue that I see people making, the next problem that people usually have is when they are asked to take a field sobriety test and they don't tell the officer that they have some physical limitation. You have to understand that you are not required to take a field sobriety test. Unlike a chemical test, you don't have to take it. So now the officer can obviously encourage you to take the test and put it in his report that you refuse to take it, but not taking a test will not subject you to any type of further penalty. If you have a physical limitation, and these tests usually require you to have a good deal of balance, like the walk and turn test, the one leg stand test, the horizontal gaze nystagmus test. Some people cannot perform these tests because of some physical limitation or some eye issue. So if you can't take the test, I wouldn't take it. Finally, with regards to the final issue that I see people making, and it's a problem, is refusing the blood or breathalyzer test. This is a big issue. You don't have a constitutional right to refuse a chemical test. If you're asked to take the test, you take it. Now, there's been a lot of litigation over blood evidence, and people sometimes get confused by it. A couple of years ago, the United States Supreme Court ruled that police needed a search warrant to obtain your blood. And that remains the case. Police do need a search warrant to obtain your blood, but if you refuse a blood test in Pennsylvania, Pennsylvania can still impose a civil sanction, which is a license suspension, regardless of what happens in your criminal case. So your criminal case could be thrown out, or you could be found not guilty, and PennDOT can still suspend your license because the civil sanction of the license suspension is a non-criminal penalty. So it's not subject to any type of Supreme Court ruling, and Pennsylvania has the ability to do that. The Supreme Court decision didn't in any way affect breathalyzers, so there is no search warrant requirement on a breath test. The Supreme Court said that blood testing, unlike a breathalyzer, is a severe intrusion on a person, and therefore a warrant is required. Now, there's been a lot of litigation over whether or not a person consents or can't consent to something where police need a search warrant. But the bottom line is that if you give consent, that is the better way to go with regards to a DUI charge. Because again, your criminal defense lawyer can't change what could happen with regards to a civil penalty. So if you're faced with the possibility of taking a chemical test, take the test. Next question. Can you explain the Pennsylvania ignition interlock device? This is a new program, sometimes called the Ignition Interlock License Program. Basically, now, if you're convicted of a first offense DUI in Pennsylvania, you can automatically begin driving again. You can obtain what is called an Ignition Interlock Limited License, which allows you to drive provided that you have this device installed in your car. Now, the device isn't free. It costs money to have it installed and maintained. So know that up front. But it does allow you to have a DUI conviction and drive the very next day. There is some paperwork that needs to be done to set it up properly to ensure that there's no gap between your conviction and when you can actually drive. So I would encourage you that if you fall within that program, that you had that set up with your lawyer before beginning to drive, obviously. Finally, with regards to that program, understand that while a first offense DUI will allow you to immediately obtain that ignition limited license, second offenses and third offenses will not. The law is a little different with regards to that. There is a waiting period. I believe it's 6 to 9 months, depending on the severity of the DUI. But remember, it's not immediate. That's a big issue that we see in our office because some people are eligible for the ARD program and don't want to lose their license. But right now in Pennsylvania, you can't have it both ways. You can't take the ARD and get the ignition interlock. You still have the license suspension. So that right now, for what I understand, if you enter the ARD program, there is a license suspension period of between 30 to 60, in some cases 90 days. But the advantage is you will not have the criminal conviction. If you take the other option of going through a trial and you're convicted, you're still going to have that misdemeanor conviction on your record, which can't be expunged. So people have to weigh it. Some people would prefer to do a little bit of license suspension in exchange for not having the conviction, while other people don't mind the conviction so much, just want to have their license. Final question. Are DUI checkpoints or roadblocks legal in Pennsylvania? Yes, they are. State police and police can establish roadblocks, but they have to satisfy certain constitutional requirements. The roadblocks have to be advertised and they have to be in an area where police have made prior DUI arrests. Those are prerequisites that law enforcement must abide by. Also, understand that you're not required to go through a checkpoint. You could actually not go through it and actually avoid it. Now, understand that police can stop your car, not because you're avoiding the checkpoint, but if you do something illegal to avoid the checkpoint. So, for instance, if you're on a one-lane highway and you do a U-turn onto the shoulder and just cross the double line, they can stop your car for that traffic violation and then obviously go through the process of determining whether or not you're DUI based on your responses to their questions or other things that they may do. But you aren't required to go through the roadblock. Also, understand that the roadblocks are legal because police have satisfied those requirements, but your attorney and you should still do the research to ensure that all those requirements are satisfied. But on their face, the checkpoints are legal. So that is the questions for this week. It is my hope that you found them helpful. I look forward to speaking with you next week. Again, if you have more questions, please email me at alfonso@gambonelaw.com. You may also visit the website, gambonelaw.com, or call the office at 215-755-9000.